Those of you living on the East Coast, good afternoon. If you are in the West, good morning. My name is Barry Nicholsberg. I'm Chief Development Officer for Estate and Gift Planning at the Carter Center. Joining me today on this webinar is Mark Williams. He's our Senior Development Associate, and we will be going back and forth throughout this particular program. We were eager to bring this to you because there are lots of people who are unaware of two very important tax laws. They have been signed, they are on the books now, and they will make quite a difference to you, especially if you don't know about them. So we're going to do our best to do that. Before we start, I just want to say that those of you who have been supportive of the Carter Center's work up until now, thank you so much. Clearly, we have only come as far as we have, thanks to each and every one of you. And thank you for staying with us. We appreciate that as well. We also know that this is an incredibly difficult time for everyone, not just in America, but worldwide, and that you would take some time to spend with us, especially on a computer when we're sort of locked into them these days. Can't really seem to get away from the screen. Thank you even more so. We hope that each and every one of you is healthy and safe, and the same for your families. And now I'm going to turn it over to my colleague, Mark Williams, and he'll get started. Just one last thing, if you have questions, there's a Q&A section at the end. Please use the chat room and please follow along. You can tap in whatever questions you like, and we will do our very best to answer all of them before this is over. We will be done within an hour. Mark?
Great. Well, I'm as surprised as anyone by this. We actually have a few folks who have joined us, so all I can figure is everyone must have run out of things to stream on Netflix. So for that, I am most grateful. Also, just thrilled to have the opportunity to be with you all virtually, though not in person. It's great material we've got here for you today, and something that will affect everyone going forward. So buckle up. Just wanted to give you all a quick overview of where it is we're going today. There are two major laws that were passed. One is the Secure Act that was passed in December, and the other, the CARES Act, passed just a few weeks ago. We'll also look at how some of these changes can be mitigated with a couple of strategic planning options. So, looking at this, you may wonder why the Secure Act was passed. Well, it made sweeping changes to all retirement accounts, basically. And so the answer to that why question is if you can see, the number of dollars in U.S. retirement accounts has grown fairly steadily from about $5.5 trillion up to nearly $17 trillion in the first quarter of 2018. And all of those funds are yet to be taxed, and the Secure Act is going to accelerate that taxation. We'll see how that happens going forward. So there are a couple of benefits for retirement savers. Barry, would you mind chatting for a moment about those?
Not at all, thank you. All right, so let's flip onto so sorry, I thought we were moving on to another slide. The Secure Act, there are a couple of very critical things you need to know. Up until January 1st, if you had become 70 and 6 months, by law, you were required to take what's called a minimum requirement distribution, required minimum distribution, RMD. I think in terms of letters instead of whole words. The required minimum distribution, if you had turned 70 and 6 months before January 1st, 2020, you had to start that. There were lots of different things involved with that. You could not add to your IRA after that. Well, things have changed. As if you have not turned 70 and 6 months before January 1st, 2020, now you don't have to take any, there is no required minimum distribution before the age of 72. And whether you were 70 and a half or older makes no difference. During the year 2020, there is no required minimum distribution. It has been delayed, just put on hold for a year. It doesn't mean you can't take the money. It just means you don't have to take the money. And that's something a lot of people need to know, because if you've been taking it for 3 or 4 or 5 or 10 or 15 years, you may be so accustomed to doing it that you end up doing it when you don't have to. Doesn't mean you can't. It just means you don't. It's not required in the year 2020. The other thing that's very important about this is that no matter how long you want, you can continue to add to your IRA from this point forward as of January 1st of this year. And so where previously, once you started the required minimum withdrawal, you couldn't add to it any longer, now you can. And that too is a major and critical change. Back to you, Mark.
Thanks, Barry. So let's talk about these required minimum distributions. For those who may not have reached that point yet, the warm and fuzzy IRS, who loves us all so much, basically looks at everyone and says, we believe you only have a certain number of years yet left to live. And a required minimum distribution basically just takes that number they say we're going to live and divides it evenly. So any money that's in your individual retirement account or other retirement accounts must be withdrawn based on those numbers, as you can see in our example. Barry mentioned before, there are no required minimum distributions in 2020. That is thanks to the CARES Act that went into effect, and we'll follow up on that again. But just for everyone to remember, no need to take any required minimum distribution this year. The government has said we want to allow you to keep your funds invested since the markets have done so terribly. But going forward, now we have double the pleasure, double the fun, double the set of rules for everyone. So as Barry mentioned, if you turn 70 and a half in 2019, you've got the old rules that apply. 2021 and forward, you have to take a required minimum distribution. And those lucky enough to get the second set of rules, turning 70 and a half after January 1 of this year, you will have to wait until 72. So if that's in 2022, 23, as soon as you hit 72, that's when required minimum distributions kick in now. So there are a number of additional benefits, as Barry mentioned too. This elimination of the age for making contributions to an IRA for workers, a big deal. And there have been no changes to qualified charitable distributions, which is great. For those having to take out a required minimum distribution, the IRS lets you give away up to $100,000 of that distribution each year to charity instead of taking the money themselves. It's great. You don't have to pay any taxes on the funds, and you can give more to charity if you so choose, which we hope you will.
Just clarify that, Mark.
Yes,
you don't have to pay taxes on the income, because when you withdraw your required minimum distribution and you get it yourself, then you must pay income tax on that. You hadn't paid it up until then. A Roth IRA, you already have paid your income tax, but on a straight IRA, you haven't. What Mark just said is absolutely true. You can inform your administrator that rather than send you money, whatever that required minimum distribution, less than that or more than that, you can have that sent to the Carter Center or any other organization. What we're telling you here today is as applicable to your local hospitals, your alma mater, your libraries, theaters, social service agencies. It applies across the board. There is one slight exception to that, and we will get to that in a little while. In the meantime, what we're telling you is hang on to this information, because we're not just talking about the Carter Center here. We're talking about all not-for-profits. And while we greatly appreciate your support, we know that there are other places that may have your interest, and we want to make sure that you have the best possible information all the time. So with that, Mark, I've interrupted you enough. I'll let you go back.
Thanks, big guy. So as we talked about these qualified charitable distributions from your IRA not changing, let's talk about what did change. So the most important thing to come about from the Secure Act was the elimination of the lifetime stretch for people who inherited a retirement plan. So what was great about that, before this change in December, is people who before, say if you're a young person, a 20-year-old who inherited your grandmother's IRA, you probably had 70 years or more that you were able to keep that money invested and take withdrawals over that length of time. That's just not possible anymore. So you don't have the opportunity to have the funds there producing a greater income for you and ultimately going farther. Now, under Secure, all of the funds have to be dispersed within 10 years. And so let's look at this because it's very important. The old stretch rules, if we assume that there was a person who was 50 that inherited a $500,000 IRA, that warm and fuzzy IRS says again, this person only has 34 years left to live. So they would have had 34 installments or 34 years that they could have taken the payments out. It's a much lower number versus 10 years. So if you have to take withdrawals of $500,000 over 10 years, if you did it equally, it would be 50,000. But as Barry mentioned, you don't have to do it in year 1 or 2. It could be in year 3, 5, however you chose to do it. The point is the same, though. The tax bill that's going to be due on that ultimately will be greater. And so the need for planning has just become so important. With those changes, you may be asking, does the lifetime stretch still apply to anyone? And fortunately, yes, it does. Spouses, nothing has changed there. You can still give all of the funds in your IRA to your spouse, and they can withdraw those over their life expectancy. So this can be important if you have a spouse who is significantly younger than you, because the next one, non-spouse beneficiaries less than 10 years younger. Oh, what the heck does that mean? That's a lot of words. So I like to kind of think about it in this way. So let's say that you've got 2 siblings, a brother and a sister. Say your sister is 9 years younger than you, and your brother is 11 years younger than you. So if you chose to leave your IRA to your sister, who is 9 years younger than you, she would be able to take those payments out over the course of her lifetime. However, if you decided that you were going to give those IRA funds to your brother, who is 11 years younger than you, he would have just 10 years to liquidate all of those funds and would owe a much greater tax bill. So if you maybe dislike this brother a little more, give him the IRA and give some things else to this younger sister. But just an illustration of that point, it's so important to pay attention. So the last 3 of the 5 who still get lifetime stretch are basically considered protected beneficiaries: the disabled, the chronically ill, and minor children. The minor children, very important to pay attention to here for the parents who are listening. They do have technically only a 10-year limitation once they reach the age of majority, and that's defined by state law, but generally it's 18 to 21 years old. So please do be aware of that. Children don't actually get much benefit from that either.
They don't, and it's not just parents who need to take that's grandparents and great-grandparents. If you are planning to leave part or all of the remaining funds in your IRA to children less than 18 years old, it could have a serious detrimental effect on them. And we'll be getting to that in just a moment. Back to you, Mark.
Absolutely. Thank you. So some of you may be wondering, sort of how this all factors into your personal situation. And so we should talk about some things, basics on tax. And the U.S. has a progressive income tax system with 7 brackets. And it's progressive because as your income goes up, you have to pay more in taxes. And what that means is inherited retirement funds are basically considered to be additional employment income on top of what your base salary is. So you pay the highest rate. I really want to drive this home. If you'll take a moment to look at the tax rates, these are for a single individual filing. You can see at the 12% rate, the tax rate, the cap on income is about $40,000. So it's easy to see if you're a parent, a grandparent out there thinking about giving these IRA funds to your children or grandchildren, if they're toward the upper end of one of these tax brackets, the impact on your gift to them could be dramatic. Again, if you take a look, if you've got someone earning $40,000 in a 12% bracket, any dollar basically above that gets taxed at 22%. So again, you've got a son who's making $40,000 a year. He's paying about $4,600 in taxes. If he were to inherit an IRA from you, from his grandparents, and decided that he was going to have to take equal installments of that $500,000 over 10 years, he's all of a sudden got a $90,000 income and his taxes have tripled. He's lost $11,000 of the gift you intended for him to taxes. And there are some things that can be done about that. That's what we're really here to share with you today. As Barry mentioned, yes, of course, it is super, super important. Any of you who have these folks in your lives, the disabled beneficiaries or the chronically ill, the minor children, you've really got to be aware of the fact that the money they inherit could affect their eligibility for Medicare and Medicaid. It could impact the amount of money they're getting from Social Security for disability income. Financial aid for students is at risk, as are federal and state means tested assistance programs. So it really, really is important to talk with your advisors about this. Barry and I would be happy to talk with you about it as well if there are additional questions you have on these, but please do talk with someone. So this is really the whole point of what we're trying to say now. Strategic planning could not be overstated in terms of its importance. Giving retirement funds that are highly taxed to charity does avoid the issue with the high taxes, and it helps your loved ones if you give them assets that qualify for step-up basis. Now, I know that's probably a little bit of a foreign term, so let's talk about it. So basis is an interesting concept. Basically, all it is the IRS saying, okay, this is what you paid for something. Let's say that you went and you bought a vacation home, a beach house. You bought it for $100,000. If it appreciates to $1 million in value, the IRS still says, no, your basis, what you paid for it, is $100,000. And if you turn around and sell it, we'll let you take your $100,000 out. But any profits you had above that, you owe taxes on. And so that's actually quite important if you think about it in terms of stock and the different types of property out there. I've been also fond of thinking about it this way. Let's say you've got this really great rich Uncle Warren who lives out in Nebraska. He's really got this great little company no one's ever heard of called Berkshire Hathaway, and people call him the Oracle of Omaha, and he just loves you so much. He's decided to leave you $1 million worth of Berkshire Hathaway stock in his will. So you're very thrilled by this. Sad Uncle Warren's gone, but you realize when you turn around and get ready to sell that stock that you don't owe any taxes on that. Why is that? It's because you got step-up basis. So if Uncle Warren had decided to give you that stock the day before he passed away, whatever it was his cost was, is transferred to you. You basically are going to owe taxes at the same level on that investment that Warren Buffett would have. So that's the easiest way to break it down, I would suggest, is by saying, oh, Barry, please.
I see, Mark can't help himself. He is an attorney. And although I have tried rather unsuccessfully to help him learn to speak in English, he hasn't mastered it yet. So let me try this. Your uncle has purchased a stock for $100 a share. And that's his basis because that's what he paid for it. And when he passes away, it's worth $1,000 a share, and he left it to you. Your basis, essentially what you paid for it, is now what his would have been had he lived. So your basis is $1,000 a share. If he left you 1,000 shares, it's worth $1 million. You go ahead and sell those shares on the day you inherit them, you get $1 million tax-free. But if your uncle gave you those shares one day before he passed away, then his basis, which was $100, that's what he paid for it, becomes yours. Now you sell it at $1,000 a share. You've taken in $1 million, but you owe all the money that the $900,000 that otherwise you wouldn't have had to pay tax on had your uncle waited one more day. And so that's what step up means.
That's right.
take it.
Thank you, Barry. That it is essentially a reset of that value back up to what the market would be willing to pay for it, or whatever the value is on the day that you got it. So it's a really powerful planning tool. One of the things I do want to emphasize is that with the changes in Secure, it is so much more important to pay attention to the types of assets that you're leaving and to whom you're leaving them. This is one of the real important parts. The middle class has an ability to use this concept of step-up basis to really plan effectively and efficiently, especially when the brunt of the tax is likely to be borne from Secure Act on those retirement account funds by more of the middle income class households. So we really wanted to just drive home how important this topic is. I know it's a little confusing, and we're happy to answer questions on that in Q&A. Sorry. So what we were going to talk with you about are a couple of tools and techniques that you can use to get around these benefits lost under the Secure Act. Barry, would you mind picking this one up?
So the charitable remainder trusts are a pretty straightforward way that you can move your money from your IRA to your friends who are, or siblings or whoever who are more than 10 years younger, less than 10 years younger than you. And you could leave them to your children, your grandchildren, would make no difference without paying those heavy taxes, without having to, not required within that 10-year time frame. You can create a charitable remainder trust. There are two kinds. The charitable remainder annuity trust, which is you fund it once and once only, and the charitable remainder unit trust, which is funded perhaps multiple times. You don't have to, but you can. The advantage of one versus the other, an annuity trust will pay the exact same dollar amount to those beneficiaries as long as that trust is in existence. And so if you said they're going to get 5% for the rest of their lives, but they can choose when to start, the point is that trust is not funded with your IRA money until you pass away. If you want to leave tax-free something to children or grandchildren or friends or whoever, you can give your house, your jewelry, your stocks, bonds, T-bills, whatever. You can leave all of that, all your real estate. Every part of that can go without necessarily having them incur a tax on it. But your IRA, any sort of retirement funds, a 403B, a 401k, all of that is now under this new 10-year rule. So if you create a charitable remainder trust, whether it's an annuity trust or a unit trust, it needs to be done through an attorney. It's a legal document. It's an actual organization unto itself. We are capable of doing that for you. We have done that now for several folks, where the Carter Center becomes, we can help create the paperwork. We can give you all the paperwork, which we then encourage you to give to your attorney and make sure that it's really in your best interest, which we certainly hope it will be. We will do that for you for free if the Carter Center is named as at least 51% beneficiary. But there's certainly no reason that you need to use the Carter Center for it. There are plenty of attorneys. My advice to you, strong advice to you, is that you find an attorney who specializes in trusts and estates. I've known far too many people who have said, I've got a great friend from high school. This guy is amazing. And he's a real estate attorney. they don't necessarily keep up with the latest trends in trusts and estates any more than a trust and estates and attorney keeps up with real estate tax law. So I would encourage you to find someone who specializes in this area. And just so you understand, again, that trust does not have to be funded until the day you pass away. And then it will be funded with your retirement accounts. Now, it could be funded with lots of different things. It could be funded with the sale of your house, with the sale of stock, with whatever you want. But where that has the step-up basis and no minimum or maximum requirement as to how much that someone has to take out, as we've said, your retirement funds will be subject to this 10-year rule and not only be heavily taxed, but also may disqualify your loved ones from resources they otherwise would have had available, as Mark said, such as Social Security, disability income, or student aid, or Medicare and Medicaid. So you just need to be careful. But if you give the money, if you create this remainder trust and make sure the remainder trust gets what's left in your retirement account, then there's no taxes due because it's a charitable remainder unit trust. Also, one last point.
Go ahead, Barry.
Just one last point, Mark. You can leave whatever you want as from part of your retirement account. Let's just say you had $100,000 in there on the day you pass away. If you give it to your grandchild who's 25 years old, that individual must take that $100,000 within 10 years, and there's taxes due. If you give it to a not-for-profit like the Carter Center, there are no taxes due. Carter Center is tax exempt. And so lots of folks will leave the Carter Center, their retirement account or part of their retirement account, because there's no taxes due. And then they leave their house and jewelry and real estate and stocks and to their friends and family. And that's a way of making sure that the law is met and it does not have an adverse effect on the ones you love. Mark?
Absolutely. Thank you. That's a very good way of putting it. This is really a tool, if you use the IRA funds instead of the others that qualify for step-up basis, that can help you take care of the charitable causes that you love most, and also help those family members or loved ones that otherwise would have to deal with the 10-year payout rule. So it's really a tool to be used to benefit those two groups with those IRA funds. So perfect explanation. Thank you, Barry. And on that same point, a charitable gift annuity is another strategy that basically kind of takes the same approach. It's not quite as formal or as difficult to set up as is the charitable remainder trust, but it's a really great way, again, to use those heavily taxed retirement plan assets to create a lifetime income stream for your loved ones who might otherwise have to take these funds out in just 10 years and pay lots of taxes. So this is a really great way to start thinking and be strategic about what you own and giving the right things to the right people. So how does this work? Basically, in exchange for $10,000 or more, the Carter Center will establish a lifetime income stream for your loved ones. So the strategy part of this, the planning part of this that's so important is this discussion that probably should be taking place. You talking with your family, your financial advisors about when would be the best time to receive these funds. Because if you take that approach, if you really are deliberate about this and you try to look forward, you could do so much more with those retirement funds. And why is that? Well, if you are willing to plan around retirement years and defer some of these funds from the annuities for a few years, you can actually get a better return on that. And you can actually avoid the issue with those inherited IRA funds being taxed at the highest levels. So one of the things that we like to talk about with these annuities is What exactly goes into setting the rates of return? They're generally between 4 to 9%, depending on the ages of the people who are taking out the annuity, whether or not those annuities are for one life or for two. You also have to pay attention to things like male or female. So these are all important considerations. So as you see, you'll want to talk about those with your family members and your loved ones. Now, both of these strategies, the trusts, the annuities, you really, really do need to take the time to sit down and to plan around these, because you want to customize them to the needs of your loved ones. You don't want them paying unnecessary taxes. Yes,
we have
Barry.
a question that I think needs to be answered right now. The question is, can I use my IRA funds to establish one of these charitable gift annuities?
So that's a great question. It is easy to do that. There will be taxes due. If you decide to do this while living, you'll have to withdraw the funds from your IRA, pay the taxes on them, and then basically give the funds over to the Carter Center or a charity of your choice to establish the annuity for you. There would be a tax deduction available along with that gift, so that's part of the calculus. Barry and I would be very happy to model those specifics for you individually. But if you were to make this gift after you pass, say in your will, you make the gift for a charitable annuity for one of your loved ones, there would be no taxes due on those funds leaving the estate. There's an unlimited charitable deduction for them. And then the person who is receiving them receives the full value of it, and they would pay ordinary income tax on the annuity payments. So it's a win-win, a very powerful way to take care of your loved ones. And again, it's not exclusive. You could do something like this in addition to giving them the assets that qualify for step-up basis. So yeah, what we're saying here basically is, we have a number of really wonderful opportunities to work with you on your planning, to work with your advisors, and if you're supporting our work, if you're interested in doing more, finding mutually beneficial ways to partner, these are some really excellent strategies we enjoy talking with you about. And we'd also invite you to consider joining with those who have included the Carter Center in their wills. Barry, do you mind taking the temporary provisions from the CARES Act?
So on March 23rd, 2020, the President signed into law what is known as the CARES Act. There are some things that happen right away, and the next slide should help us understand what they are. First of all, there is a $300 deductible if you give money to charity, whether that's the Carter Center or any other charity, and whether or not you itemize your deductions, you still get that $300 deduction on top of the standard if that's what you use. So that's the first thing. It's only good in 2020, but it's certainly intended to help the not-for-profit community, no question about it. When you give cash up until the year 2020, the amount of cash you could give was no more than 60% of your adjusted gross income. The adjusted gross income is what you got left after all your deductions. So we'll say you made $100,000 last year, and your deductions were $30,000. So your adjusted gross income was $70,000. Up until 2020, you could give 60% of that, or $42,000, away to a not-for-profit tax-exempt organization, no questions asked. In this calendar year of 2020, you are allowed to give 100% of your adjusted gross income. You think to yourself, wait a minute, how can I give 100% of my adjusted gross income? What am I supposed to live on? There are people who have income through royalties and whatever it is, sale of, I'm drawing a blank, but you get the idea that there are other ways for you to have income. There are lots of people who do. Some of them have dividends. Some people sell stock. Whatever it is, you are legally allowed to give up to $100,000 away. Businesses are now allowed to give in this year up to 25% of their pre-tax profits to not-for-profit organizations, tax-free. Currently, that is a 10%, not 25%. Also, just for the record, those corporations that do provide support to the not-for-profit industry average just less than 1%. So even though they have raised the cap to 25%, since the overwhelming majority give less than 1%, I'm not sure that's going to have a great effect. And finally, as I had mentioned earlier, the required minimum distribution for 2020 has been eliminated. So that's what we're talking about with the CARES Act. That is specific to address the issues that the government thinks might help the not-for-profit industry, businesses survive during this pandemic. Mark?
Thanks, Barry. So one of the other things we were very interested to share with you is another strategy that we've come up with. One that we'd really like to talk to you about is endowing your annual gifts to the Carter Center, whatever those gifts may be. By permanently funding those, you could remain a permanent member of the Ambassador Circle and go on and forever fund the work of the Carter Center. It's as simple as making a bequest in your will or specifying a beneficiary designation in one of your retirement accounts, and sending a note along that says you'd like that to be used to fund our endowment and your place in the annual circle in the annual fund forever. So what we've done, Barry, I think I saw you leaning in there. Did I miss something?
No.
No? Okay. So the annual gift amount, basically what we've done is try to be extremely conservative in thinking about this, saying that if we invest and we only expect a modest 4% return, a gift of 25 times whatever it is your annual support level is would be enough to sustain that forever. Again, it's at any level, something that could be done by almost any person and with almost any type of property. So
this is a great way to support the Carter Center. If you are a member of our Ambassador Circle, or you're thinking about becoming a member of the Ambassador Circle, which is $1,000 a year, to support it this way means that you will be a permanent member of the Ambassador Circle. And you can rest assured that as long as the Carter Center is in existence, it will receive $1,000 a year of interest in your name. And there's really hardly a way you can recognize an organization like the Carter Center better than by making a permanent gift like that.
Thanks, Barry. And now we just wanted to conclude hitting basically the most important points here, and that is really that you can have a far greater impact than you likely could have believed. And it's really by using these tools and concepts that the wealthy generally use, making sure that you're giving the right things to the right people, those step-up assets to the people that you love, and paying attention to the taxes due on things like your retirement account funds. You could do so much more by really focusing on what you're giving. A charitable gift with those highly taxed funds can go much further for the charity, and it can go much further for your loved ones, giving them a lifetime income and providing a solid foundation for the future. So we hope that you'll take a few moments to consider these. And again, if Barry and I could model any of these steps for you, we are very happy to do that. We'll sit down and talk about your individual circumstances with you and your advisors, or you alone. Please just don't hesitate to reach out. No question is too big or too small. And on that note, again, these are just very trying and difficult times, and we want to remain committed to you here as an advisory resource. Barry and I have a great privilege to be able to be here and to talk with people really with no strings attached. We have the opportunity to sit down and provide you with models and illustrations, and also to talk with you about the work that the center is doing and how you're helping to support that as well. So we're just very grateful. So please do not hesitate to reach out. Happy to talk with you guys. We've made that much easier. Here you can see on the screen our 2 cards that we've got, Barry's and mine. You could click on either of those and it will launch your email application and be just as quick and simple as sending a quick message to us with any questions that you may have.
Now, you're able to click on those things because we sent you a copy of the PowerPoint.
That's right.
You've got it in your hands or on your computer. You can go back and look at it, but if you have specific questions for us, you can email us. You can also use that phone number on those cards. I will tell you this, we're all, of course, working from home at this point, but our phones do forward, and they forward to our cell phones, so you can call pretty much anytime and find us. One other thing I did say earlier in the presentation was that there are a few exceptions to charitable gift annuities, or at least those who can establish them or offer them. The Carter Center is one that is an organization that has the capacity to offer them because by law with individual states, not only do we have to register, but we also have to have a substantial reserve. And the reserve is critical because if you take out a charitable gift annuity with any organization and that organization, heaven forbid, closes, then are you out the money? And the answer is no, because there are reserves that are held so that the Carter Center can't touch the reserves. And if you give us $20,000 to start an annuity, we're going to put that money in reserve. We're not going to touch it. And so that money is there on a just in case basis. And sometimes that's incredibly important. So before you say to your local theater or museum, I'd like to establish a charitable gift annuity, you need to make sure that they can do that. And almost all national organizations can do it. But I know that it's not as popular as I thought it would be. My alma mater, for instance, when I was asking them about charitable annuities, they said they only had 3. And I thought, well, that just doesn't seem like you guys have really tried very hard. But it just is what it is. If an organization doesn't have at least 100 annuities, it's very hard to maintain that portfolio.
And one thing I would add on that too is, as you are out there and you're having these discussions with these organizations about charitable gift annuities, please be sure to ask the question on the rates of return that they're asking. Are they following the American Council on Gift Annuity guidelines? You may from time to time find organizations offering higher rates or lower rates than others. And the issue is that unless you comply with the American Council on Gift Annuity rates, you run the risk of basically angering the IRS. And so it's an important question to ask, and one that we want to make sure that you're aware of so that you can ask it.
Well, it's not just angering the IRS. It's if they're not following those guidelines, what other guidelines are they not following? Are they not holding monies in reserve? And those are really important questions for you to ask.
Absolutely. Thank you, Barry. And we actually do have another question. Someone has written in, are existing inherited IRAs grandfathered, or will the required minimum distribution calculation change? I have great news. Fortunately, if you have already inherited that retirement account, you are still good to go. You have the ability to take those payments out over the life expectancy that the warm and fuzzy IRS has given you.
Yes, if you inherited the money before January 1st, 2020, it's still the old rules.
And we do have another question here, a clarification question. It's asking, so a charitable remainder trust is a vehicle for providing an income stream to a beneficiary for a period longer than 10 years, but directly inheriting an IRA would require 10-year distribution. Yes, absolutely. That is correct. You have got it 100%. That came in anonymously, so I cannot clap for whoever wrote that question, but well done. You followed our discussion. So Barry, I'll ask. Yes.
I'd like to actually bring up another point. We've got a few minutes here. This was not part of the presentation, but I think it makes sense. There's one other kind of trust that I would like to talk about because it's really wonderful trust. It's called a charitable lead trust. And this is one in which you can put money into this trust before you pass away or when you pass away. And the trust will pay your beneficiaries, whoever they are, 20 years later. I know that sounds a little weird at first. For the first 20 years, the Carter Center or another organization would get 5% of the amount that you funded into. So if you put $1 million into this lead trust, the Carter Center would get 5% of that every year. Well, of course, it's being invested in trust, it's making money. And so your 3 grandchildren who are currently 10, 13, and 15 in 20 years are 30, 33, and 35. And they are far better able to handle receiving a large bit of money. So you're going to ask the question you should be asking is, what kind of tax are they going to be liable for? Because it's a charitable lead trust, the day it's established, you get a tax deduction for the amount of money you funded. So you get $1 million tax deduction if you put in $1 million. Your grandchildren, when they inherit the money, are only responsible for paying tax on anything over and above the initial amount that funded the trust. So the trust has been invested well. It's gone from $1 million on day one to $2 million. And now I want to make it to $2.5 million. So it now has $1.5 million more than what you originally established. The first $1 million that goes to your grandchildren is tax-free. This $1.5 million is taxed, but not at income tax. It is taxed at what the adjusted federal rate was on the day it was established. In this month of May 2020, the adjusted federal rate is 0.8%. So each of your 3 grandchildren will inherit $500,000 that needs to be taxed. They will pay 0.8% on that $500,000. And then the other $333,000 that they inherited, which was their part of the first $1 million, there's no tax on that at all. There's just nothing like this available where there is so little tax that will have to be realized at the end when that trust dissolves. I would encourage those of you who have the resources to consider that, because it's a huge benefit to you because you get significant tax deduction, to your children or grandchildren or great-grandchildren, because they're going to end up with a good sum of money without having to pay a lot of tax on it. So I know nobody asked that question, but I thought it was important enough to drag on about for a few minutes. Mark, do we have any other questions? Mark, you're muted.
Thank you. Thanks to Joe Coleman on this. We do have another question here, a good one, a detailed question. And Joe has asked, can a person make IRA contributions with pension or Social Security income? And there's a follow-on question. So I'll take question 1 first. So as long as you're working after age 70 and a half, Secure allows you to make contributions to an IRA. So the funding source really shouldn't matter. I believe the key here is whether or not you are working. So if you're putting in pension or Social Security funds or regular work wages, it really should not make a difference. And so the second question, which is part of the first, is can a beneficiary make an IRA contribution with funds that they inherited from an estate IRA? And the answer to that question would be, well, basically up to the annual limits. Again, there should be no issue there. The thing is, if you are getting these funds and you're paying taxes on them and you want to contribute those into an IRA, should be able to do that. I think maybe the question is also asking whether or not there would then be a deduction available for those, maybe reading through the lines there. And that's an interesting question, because if you've got it, you've paid taxes on it, and then you're contributing them into an IRA, much like people do who are working who don't have access to a 401k, there would be a deduction available for that. And what I can tell you is this is the first time this question has popped up, and I don't necessarily feel comfortable giving a definitive answer, but I feel comfortable giving an answer that says, as long as the normal rules apply, this person should be able to contribute those inherited funds into an additional IRA.
If the taxes have already been paid on that, then you create a Roth.
That's actually a great idea, and one we haven't talked about enough here today, but honestly, a Roth is one of the best possible options there, because those earnings, the increases in value of those investments, would go on and would remain untaxed forever. So that's a really powerful way to do that, and a way to not have to worry about some of these rules quite as much. Barry, great. We got a question on charitable lead trusts. And the person here is asking, so a charitable lead trust pays the charity each year that the person is alive, but then pays my beneficiaries, child or grandchild, when I pass?
The charitable lead trust pays the not-for-profit for 20 consecutive years. And then the trust dissolves and the money goes to the beneficiaries, whoever they were named. Whether or not you're still alive at that point is immaterial.
Excellent, thank you.
It's a way to avoid generation skipping tax. You know, you're 50 years old now and you have the resources to leave to a child or perhaps a grandchild. And 20 years later, you're still happy, well, and doing fine. And that child or grandchild now takes on that money. It's not inherited. It's simply received. You don't have to pass away.
So, Barry, I'm seeing another question here, asking if we could maybe talk again for a moment about step-up basis. And I know that got to be a little bit of a muddy conversation. So I'm grateful for the question out there, Anonymous. Much appreciated. I think it makes sense, again, to think about it this way. Again, basis is what you pay for something. And generally speaking, you want the basis to be as high as possible so you don't have to pay taxes on it. Going back to the example about inheriting something, again, the real quick and easy way to think about this is if you inherit stock or other property from a person after they pass away, the great news is you're not going to have any taxes that come due. You get a step-up basis, essentially the fair market value when you receive it. But if this person were to give you that same property the day before they passed, you will owe taxes on some portion of that, basically the difference between how much they paid for it and how much it's grown, and there's a tax that the government applies. So that's probably an oversimplification, but trying to cut out all of the numbers and just see through to the concept. You'd rather get the money after the person passes, or the property after the person passes, because you don't have to pay taxes. But if they were to give it to you just the day before they pass, there would be some taxes due. And in our example about the million, I don't know about you all, but I'd rather have the full million than some part reduced by taxes. So
I want to make this just a tad more complicated, which is not like me, but I'm going to do it anyway. When someone inherits that stock that has increased in value, there is no tax due at that time. It's only when they sell the stock. So If you bought it for $100 and it was worth $1,000 on the day it was inherited, there's still no tax because it has not yet been sold. If it sells for $1,000 a share, there will be a tax on that $900 profit. If the person holds on to it and it grows to $3,000 a share, then the tax will be paid on the difference between the $1,000 that you paid and the $3,000. So it's very important just to understand that until that asset is liquidated, is turned into cash, there is no tax due.
Absolutely. Thanks, Barry. And, another way to maybe think about this, there was a comment here, the warm and fuzzy IRS. So I can't help myself on the concept of step-up basis. Think of the IRS like a warm and fuzzy mafia enforcer out there. They don't mind you pulling your money back out, but if you've made any money, by God, they want their cut. That's step-up basis.
That's perfect.
All right.
That was very good, Mark. I'm proud of you.
I'm getting there.
Yeah.
So someone's asking here now if we could explain the income tax consequences of a charitable gift annuity upon contribution and as payments are received. So that's a good question, and that's kind of a complicated question. Barry, do you fancy a go on this one first? Or?
If it's funded with cash, so I took $10,000 from my savings account and created this charitable gift annuity. As I receive money, as I receive my annuity payments, roughly 3/4 of those payments will be tax-free until I turn 78 years old. The other part of that payment, the other 25% roughly, will be taxed at regular, whatever my income rate is. If it's 10% or 25% or whatever, it will be at that rate, unless I funded with appreciated securities. If that's the case, then while I still get that 75% tax-free, the other 25% is going to be taxed at capital gains and not at ordinary income, which may save someone a great deal of money.
Most certainly. And to the first part of the question, too, about the income tax consequences of the contribution, the great part about that is that there's actually a charitable deduction available for the establishment of a charitable gift annuity. And again, unfortunately, there's not a real clear-cut and dry answer to what that deduction looks like. It depends on the type of property contributed. It depends on the amount of time that you're willing to wait or not between the start of the annuity. Again, things like how many lives, whether or not they're male or female, all of these things are factored in and will make a difference to how much that deduction is for you specifically. So please, if we can help model that for you, very happy to do that.
And just understand what he just said, male or female, only because women are, according to the Internal Revenue Service, able to live longer than men, which I don't know is necessarily true, but according to them it is. And so there are different rates, annuity rates, because the IRS expects women to live longer.
Yes.
With that, we've come to the end of our hour. If you have other questions, we would be delighted to hear from you. Please email them or call us directly, and we'll get right back to you, we promise. On behalf of Mark Williams and everyone at the Carter Center, I want to thank you all so much for spending this hour with us. We hope you have found it informational and helpful and possibly a little bit fun. Folks, please stay healthy, stay safe. God bless.